Hello and welcome back to my channel. I am attorney Deborah Lelli, and today we are concluding the 3-part DUI series. Today's video will cover the judicial process and any possible defenses that you may raise. New to my channel, don't forget to subscribe and activate the notification bell to stay up to date on all upcoming videos. Let's get started. If you haven't already, make sure you watch video 1 and 2, which covers the initial stop and the state-required chemical testing. Generally, after the DUI arrest, the charges will be forwarded to the prosecutor to begin the judicial process. The first hearing you are going to have is the arraignment hearing. At this hearing, the judge will go over your charges and will go over the minimum and maximum possible sentence. A misdemeanor DUI carries a maximum sentence of 6 months in jail, $2,500 in fines, and up to 5 years of probation. 0.08 is the legal limit. However, you can be charged with driving under the influence if you're impaired to the slightest degree, which sometimes can put you under the 0.08 legal limit. However, if your alcohol level is up to a 0.15, then the minimum jail sentence would be 10 days in jail. The fines and fees that you will receive will be approximately $1,250 plus surcharges. In addition to these fees, you will be required to attend alcohol classes and install the interlock device. If your alcohol level is between a 0.15 and a 0.20, the minimum jail term would be 30 days in jail. The fees and consequences remain similar, however, the fees would generally jump about $1,000 more. Now, if your alcohol level is above a 0.20, the minimum jail term would be 45 days in jail, and the fees and consequences again would remain the same. However, you would have a longer period on the ignition interlock device. Keep in mind that if you're receiving a second misdemeanor DUI within 84 months, the fees and jail time can substantially change. If you are charged with an aggravated DUI, you can be charged with a Class 4 felony or a Class 6 felony depending on the circumstance. A Class 4 felony carries a maximum sentence of 3.7 years in prison, and a Class 6 carries a maximum of 2 years in prison. After the arraignment hearing, your case will be sent to a pretrial conference or a status conference. Here is where we obtain the discovery and start looking at any possible defenses in your case. Remember, in Arizona, you can be charged with a DUI if you are found to be in actual physical control of your vehicle while under the influence of alcohol or drugs. For example, if you are found sleeping in your car on the side of a road or in a parking lot, they could charge you with being in actual physical control if you were under the influence of alcohol or drugs. A couple possible defenses that could be raised would be no probable cause for the arrest, no reasonable suspicion to initiate the stop, problems with the chemical testing, denial of your right to counsel. The list can go on. As an attorney, we will advise you of your possible defenses and the best option for you to take. If your case cannot be dismissed prior to trial, then you can raise these defenses during a jury trial. If you or someone you know has been stopped for DUI, give us a call. We would be glad to review your case and point out any possible defenses that we may see. If you have any questions, don't forget to leave them in the comments or give our office a call at 602-456-1427. As always, if you enjoyed this video, go ahead and give us a like and don't forget to share. Until next time.